Good evening, chat. Hello. It is Wednesday night already. It's Wednesday night. Hope you guys are having, well, I mean, if you're not, but hope you're having a good Holy Week. We are partway through it. So, I mean, we're almost to, Holy Thursday. We are today on Spy Wednesday. This is the day when, Jesus de Cristo was betrayed. Remember, Jesus wasn't just some guy, wasn't just some broski. Was a real guy that was sent here. Not to be a king, as some out there may claim. No. He was sent here, to die for your sins. So, despite what people may tell you, don't listen to that heresy. Anyways, we are going to get ready for the Karen Reed stuff, guys. We are ready to rock and roll. My name is Sean, also known as Potentially Criminal. We've got some fun stuff tonight. The Karen Reed final pretrial. Now, what is there left to talk about? Well, there's some interesting things left, guys. Like, one of them is what's going to happen to Turtleboy, because remember, he's a member of the press, but he was also set and subpoenaed as a witness. So what are we going to do with that? What are we going to do about the Sallyport footage? Because remember, one of the hearings we learned, I actually have a bunch of that footage sitting around that might be unavailable. What's going to happen with the ARCA witnesses? There's more about that. There's more about what are we going to do for the jury view? How are we handling a lot of things here? So there is a lot to go over. Using Karen's statements, the prosecutor wants to use those on opening. There's a lot to go over, and we got to get to it. Danielle says, let's go, or let's go. I'm not sure, but you could do either or. Guys, tonight we are only live on Rumble, on Twitter and YouTube. I couldn't get Rumble fired up, so I wanted to give you guys, a timely thing instead of waiting a couple minutes. So for Rumble, that might not work. So we're only here tonight. So Safa. Also, I will tell you guys, this is not the longest thing in the world. There's some breaks involved, so we'll get through this at a decent hour here. If I have enough time, we'll take a look at what's else going on. Yes, I did hear and see some of the things that are out there about Nick Rekieta's case, and like with the probation pre-sentence investigation report isn't out there, but from what his attorney has said, you can kind of discern some things. At least I can discern some things. I got some feelings on it. Hoping by tomorrow the prosecution releases their own sentencing memorandum, because that'll really, I'm sure, reveal a lot of hard-hitting information. So we'll take a look at that, and hopefully it gets out in time for the Thursday night show. And if you guys are new, we do a Thursday night show. Otherwise, why would we not do it? It's Thursday night. We do it every Thursday night at 9:30. We got a lot of topics to cover. There's a lot of interesting stuff to get involved in. Diddy has some new attorneys. The governor's mansion in Pennsylvania was firebombed while they were in. The governor and his family were inside. A new attorney has joined Diddy's team. One that you guys are all familiar with, and it's like, ooh, buddy, there's some good stuff going on. Carmelo Anthony got bonded out. One of the cases we covered a couple weeks ago, the guy involved in it has since taken his own life, and I think it's a bit of a tragic end to this, but somebody did that and took their way out. And then there's just some other things that are going on that are out there that are kind of interesting. We also have some of the stuff going on with Trump and the immigration issues, and we'll take a look at all that. That's tomorrow night at 9:30 Eastern. So hope to see you guys there. Let's see. What else do you guys have? Late in Mind Mom, Safa. I was on time, son. I was on time. You failed. Okay, let's see here. Benjamin Lewis is a new member. Well, thank you, Benjamin. Thank you for re-upping. I appreciate it. And then Base Shaman says, Kurt has been reading in his chat today, suggesting Trump can deport anyone, including citizens under the AEA. What's your take on the AEA? You shouldn't be worried about the AEA. The NDAA, the National Defense Authorization Act, basically allows detention of citizens anywhere in the world for really any reason, that's a bigger threat to anything else that's out there. So the AEA is completely fucking irrelevant. The NDAA is the bigger problem. And remember, we're worried, oh, they could rendition me somewhere. I could get hit with a drone strike right now. And you know what? That's it. There ain't nothing anybody could do about it. So I do love all the panicking and, everybody's so scared. It's like, this is where like Ron Paul was ringing the bell like 2008. He's like, the National Defense Authorization Act is a bad thing. The authorization and use of military force, the AUMF, is a bad thing. The Alien Enemies Act, like, that's not the problem. That's not the problem. We've got bigger fucking problems. We got big old fucking problems. So, Aman Razu says that's some real long-legged Mac Daddy shit. Yes, it is. Yes, it is. Oh. So, did that sandwich get any due process before you destroyed it? Yeah. Well, I mean, I took a look at it and said it was tasty, and I decided to eat it. So, it's about how it goes. Bella says a good rule is not to do something to the other side you don't want done to your side soon. I mean, that is a good rule of thumb, but I mean, all they're saying though is all they're acknowledging is, see, we could be massive pieces of shit too, which I don't really think is going to win them today. But we'll see. We'll see. So, like I said, the AEA, yeah, I mean, there's a lot of problems. There's a lot of problems everywhere. A lot of problems everywhere. So, a lot of problems. SB Sellers, because explaining how a court doesn't have jurisdiction can hold you in contempt of a legal order. It's not the order is not revoked or overruled or determined to have no jurisdiction until after the fact. So if a court tells you to do something and you're in contempt and you defy that court, the court can still hold you in contempt and address the issues of you disobeyed an order. So I think the idea, though, he thinks it's criminal contempt, I think is probably a bit much. I bet it's civil contempt at most. And I'm sure Bossberg is going to try to push it, but at the end of the day, what's he going to fucking do? He can't do anything. I mean, at some point, if I was the DOJ, I would just, the DOJ could just go, like, Judge Bossberg, fuck off. We're walking away here, son. I mean, they might go seek something out of the DC Circuit soon, but I think they're going to let him flail around and pretend to be important for a while. But overall, if you do something in the court, for example, you're in front of the court for something, you go up and appeal it, and in the meantime, you've breached court rules. And the appeals court above says, yeah, this court actually doesn't have anything, case dismissed. You're still in trouble for what you did in that court. Much the same way as an attorney, if I get into a position where I'm going to get sanctioned, and then I were to like withdraw from a case, like my client fires me and I got the court, like I did some sanctionable conduct and I get fired by my client or I ask to withdraw, well, the court's probably not going to let me if I ask, but if I get fired, I'm out. The court still holds the ability to sanction me. So just because you quit or the game's over doesn't mean it's kind of like, think about it like the NFL or really any major sport. You can do something during the game, and then after the game's over, you could get penalized even more for it. It's kind of how that can happen. So think about it that way. You're never actually done. Although if I think that's kind of where you are with that. Since I don't promote channels, because I never help nobody out. Yes, like and subscribe to KT's, K's KLF guys, her YouTube channel for trial reacts and doggos. Yes. For criminal contempt, Trump could pardon at least. Yeah, I know that's the other thing too. So it's like, I don't know. So I think that's where we're at. Let's see here. Debbie O gifted 5 subs. Thank you, Debbie. God, my voice still sucks. But overall, I feel really good. I feel energetic and everything today. Just my voice is just like dog shit tonight. So I'm sorry, Chet. You're going to have to suffer if it sounds bad. So what else we got here? But thank you, Debbie, for your support and your generosity. Base Shaman is saying, isn't it true under the habeas petitions in the AEA, the government has to prove who are they deporting is not a U.S. citizen? Well, yeah, that's part of it. People are allowed to challenge things in this habeas. They're allowed to challenge, like, am I 14 years old? Am I a Venezuelan? Am I actually a member of, trendy arugula? Like, you have the right to force the government to prove all those things. So, because yes, if you are a U.S. citizen, like, obviously you're not an alien. And if you are a permanent resident, you don't fall under the AEA. So there are things they can do. And yes, those are the basic things. You're allowed to challenge your classification. So, but remember, that's something that's gone on since, back all the way to the Guantanamo days with the War on Terror guys. Because they were being held at Guantanamo, they had due process attached, and they had the ability to challenge through habeas, like, I am not a member of Al Qaeda. And it turns out, like, pretty much most of them were, but some of them did end up getting released. Let's see here. So, Boomer says, I'm a bad viewer. Are you going to do a TLDR on the Nick sentencing? I mean, from what I read so far, White's, Frank White's sentencing memorandum kind of points out that I think Nick probably crapped out on his PSI interview, his interview with the probation department. I'm sure Nick wasn't very convincing, or they found every statement he's made in the past 3 months where he's like, drugs are cool. Everything's cool about drugs. I'd do drugs again if I could. I'm just being hampered by the fun police. I think that, or Nick really didn't convince them that he agrees, yes, drugs are bad. I should never have done them. It ruined my family's life. I kind of get the feeling Nick didn't do a very good job at selling it, or he completely just crashed and burned. I don't know, but something happened because that's the specific thing that White cites. As far as the letters go, the letter from his dad, that doesn't really, it doesn't do anything. There's not any, my son may have done wrong, but he's very strong and resilient. He'll take care of his family, by golly, and I know he could be the man he needs to be. There's none of that. It's just, Your Honor, everything on the internet's so mean. I'm going to tell you all the good stuff. It's like, all right. And then, Kayla is written like she was held in custody by fucking Hezbollah. Nick's a freedom fighter for, free speech and, people, it bothers a lot of people. It's like, no. Like Nick, it's basically like, it sounds like Nick fucking wrote it and walked up to Kayla and said, sign here. And like, so no, these were not helpful at all. These letters were not helpful at all. So I don't think he's still going to get apparently the probation department's recommending 30 days, and they want 5 years of probation and probably also 5 years of the supervised, adjudication. I don't think that's going to happen. I think he'll probably get like 2 years probation with 2 years of supervised deferred adjudication to complete a treatment plan. I'm sure he's going to get community service, but he's not going to go to jail. I don't see him going to jail. I'll still maintain that. That's my lock of the week. He is not going to jail. Still holding down on that position. So let's see here. So we'll see. Anyways, we're all done with that chat. Enough talking about that crap and boring crap. Let's talk about Karen Read. Karen Read is about to start trial, guys. They picked the jury as of Monday. They have 9 men, 9 women. And you might say, wait, that's 18 people. It is. She's going to have a 12-person jury, but they also need 6 alternates. They're planning ahead because remember, Karen Read trial was like 30 total days of trial. 30 days. That's not including, the weekends. And remember, in the first time around, Judge Bev, it was like Wednesdays were off every day. for part of the day, if not some days the whole day. And we were into May into June, so we had like the Memorial Day weekend. We worked around all kinds of holidays and stuff. So it's a thing. So there are 18 jurors. They're preparing for the long haul. 18 is a very good number. You don't have to worry about it. And from there, they start Tuesday morning. Tuesday morning. You're like, why Tuesday? Remember, Monday is the day after Easter. So I'm sure maybe some jurors said they were out of the way or something. Maybe the judge didn't want to go right away on Monday. I don't blame her. So we are going to start at Tuesday. I will not be available for that, but we will, if I'm not available during the day, guys, I will be watching at night and we'll run through and catch up. So remember, we could do the neat thing of going at 1.3 speed and skip all the breaks and do all the fun stuff like last time. And if I am available and I'm at home, we'll watch it live, but I don't know if that's going to be as easy this time around. So let's get started. Let's get started with this final pretrial hearing. So I know that there are some problems with audio and things that clip in and out. We'll work on as we get to those, but apparently from this morning, a couple of the channels, their audio got screwed up at the start. Core TV apparently had the audio running pretty flawlessly at the start. So here we go. Here we go, chat. It is time. So we are going to skip ahead here. Look at this, chat. We're already so far ahead. Look at this, 55 minutes. You're hanging out with me 56 minutes. And look what we just got done. We just got done with that.
Yay. All persons have any business before the Honorable Beverly County, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22-117, the Commonwealth.
Okay, I'm a little disappointed we don't have the other guy from before. Yay. Draw near and ye shall be heard. I missed that guy. The other guy was better, the guy with all the red hair on top. But, he's trying.
Versus Karen Reed. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for the District.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good
Reed.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms.
Remember, Victoria George, she is the former she was the alternate juror on the first trial. So there you go. If you guys wanted to see who this woman was, she's like Karen. She looks like Karen Reed. She's like maybe that's why they hired her. There's an assassination attempt on Karen Reed. She's like, there's a sniper. He's like, I don't know which one to attack. It's a body double. So there you go. But she's an attorney. She's a lot of civil related stuff, but she was an alternate juror. But she sat through the whole trial. So there you go. New face in the game. New face in the game, chat.
George. Good morning, Ms. Reed. All right, so I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that, all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is...
Now remember, chat, the Sallyport videos, remember, we saw this in the first trial. It was mirrored. It was flip-flopped. So everything was backwards. And they didn't have the guys walking around the correct side of the car if you had flipped it. They were walking around and fucking around with Karen Reed's car on the side with the broken taillight. And nobody could explain why it was flipped around, why all the metadata in the thing there, all the different headings and the different fonts, were all different and had been screwed with. Nobody can explain that. No one can still explain that. And that's an issue that's still ongoing, and the state has not helped resolve that problem. So later on, you're going to hear Hank Brennan shit his pants about the ARCA discovery, and it's like, dude, you're really screwing this up over here. So once again, the state is screwing around with the discovery.
A seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Brennan.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed, and then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need.
The neat thing is you could just give it to them. Like, this is the thing. Like, well, they got to come get it. It's like, it's your stuff. It's your stuff, and you keep screwing with it. You said you didn't have it before, and now we do. You know, like, you know, it's fluid. Like, yes, like all the fluid in your brain, because you're such a dolt. It's Hank Brennan. He's got water brain.
Because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been...
That's what they want. They want a forensic imaging of it so they can say, how do we know this hasn't been fucked with? But he's going to be like, well, no, there's all kinds of police stuff on there. Listen to him. Just listen to him squirm. But I love this. Look at her face. She's like, are you saying we could do what we finally want to do? He's going to go, well, no.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private information and other investigations. So they can go to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you.
You know, I'm not going to lie. If I was Melanie Little here, or whatever her name is here, I would come up and I'd be like, listen, Elizabeth Little, so here you go. I would come up and be like, you know, this is your fault. You guys jerked around with the DVR and you wiped it. And then you secreted files somewhere else surreptitiously. and you put that file with a bunch of other files. This is your fault. Had you not done this, had you been honest about what you were doing, we wouldn't have had to have this problem. But because the state started jerking around where they kept this damn file, what are we supposed to do? What are we supposed to do? Now, I still don't understand why Judge Bev, the first time at trial, because there's judges I've been in front of where they would have said, wait, this isn't the authentic copy. This has been messed with. And the prosecutor tried to pass it off and the cops tried to pass it off. Asses would be made to sting from that situation. I mean, like Foghorn Leghorn when he sits there and paddles the dog's ass with a 2x4. Like, a lot of judges should be, like, Bev should have gone to town on them for that. And now that Hank Brennan's doing all this bullshit, this should have been happening. Like, why? You guys caused the problem now. So we can't forensically secure it. I guess you can't show it. That would be my recommendation as a sanction. Sorry, Hank. It's gone now. You guys fucked up. And I said this before, chat. The remedy for police incompetence should be sanctions like that. Exclusion of evidence, maybe a dismissal of trial, because you know what would happen then? The people in Canton, Massachusetts, they would demand audits of their police departments. They would go to their city council meeting and say, why do our police suck? Why are they letting bad killers, like, because they think Karen Reed did it? Why do they suck so bad Karen Reed got away with it? It's the only way you have accountability. It's the only way people are accountable is when you hold their job at stake. So this is a great example of it, why it should happen. But it won't, sadly.
All right, so the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view. She can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors. But just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel.
And that's a big thing. In jury views, the attorneys for the prosecutor, defense attorney should be on the bus with the jurors. Because God forbid something happens in there, they that way they can witness it and raise an issue. Because, like, who knows what'll happen? Like, the idea that none of them would be there, but just like Hank's hanging out on the bus, like that would no. You guys, somebody, the state and the defense should have a person on that bus to monitor the jury. They have to be, because think about all the dumb shit that happened in the first trial. It has to happen. Yes, Karen will show up in like probably a blacked out SUV, or something hanging back, or like in a silver SUV. Who knows? And that makes total sense to have her there. Makes total sense to have her there. But the idea of, well, where are the rest of the prosecutors going to go? Well, fucking borrow a police car. I don't know, something. I don't fucking ride a pogo stick. It's not my problem if I'm Alan Jackson. Also, I hope Alan Jackson shaves. He does not look good with a beard.
One defense counsel can go in a car then separately with Ms. Reed, and the rest will be on the bus.
That's fine.
I do need you to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they decide
They want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
What a douchebag. I concerned, Your Honor. They want it. They don't care. Well, I guess okay. It's like he already knew they didn't want. Like they wanted it last time. It's gonna be there again. I don't know. I don't know if I like that idea. You're putting the alleged murder weapon at the scene. I think that's. I know, but if they were just gonna focus on that, that'd be great. But they're gonna go down this road of the fucking frame job shit again. It's like I don't like this. I do not like this. So, who knows?
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at sidebar about this anyway?
So we don't know when they're going to do the jury view. It sounds like it's going to be quiet. Yes, the audit was a big bust, but that's because people don't really exercise their ability to hold their police accountable. So that's kind of like a normal problem here. Do I think Jackson's banging Karen? No. So yeah, it would be better with sideburns, but he just looks weird. He looks weird the way he does his beard. But I think overall, God, where were we going with this? They can have Karen back the car up while they're at it. So we'll see what happens. We'll see what happens. But I do think, yes, keeping it private, because remember the last time it still was a circus. All the media was there and stuff. So I'm assuming they're going to try it. They're probably going to, hopefully soon. I don't know if the defense is going to want to wait till they present their case. I don't think they're going to want to do that. I think they're going to want to do it early on. And hopefully they pick a time where it gets nice out too, because that's the other thing. You got to pick a day where it's like nice out, because if it's shitty out, the jurors aren't going to pay attention to anything. So we'll see how that works. Maybe they'll say, Judge, we're going to wait for like the first day at 70. Who knows? Who knows? Traditionally in my area, when you do this, you do your jury view is like right at the beginning. First thing we do, jury's picked, opening arguments. Boom, we're going to go on a ride. But it all depends. It all depends. They're going to assume John's body and have him lying on the ground. Oh. So, they're going to have a snow machine out there just. Ooh. They'll bring Chloe back from Vermont. Anyways, let's move on.
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welchure, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welchure, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is, okay?
I will do that.
All right, thank
Thank
you.
you, Your Honor.
Okay, so Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only.
He is such a whiny, passive-aggressive asshole. He is such an asshole. Like, my God. You know, like, when the judge says, talk to me, this is where the judge should be controlling the courtroom, saying, stop with that shit, address me. He's such a little whiny, like, complainer. Just sniveling, like, well, I'm not going to hold them to the standard they held me. Yeah, they should be holding the state to a really high standard. Yes, this is how it should be. You should have a higher standard of things. Remember, you're trying to lock a woman into a box for 25 years. You should have a very high standard for all of your evidence. And you have, like, Cesar Millan coming in, basically. You have the dog whisperer coming in to talk about dog stuff. And you're like, well, this guy's not qualified. It's like, compared to yours? Like, this guy actually has a lot of experience. And the defense is going to bring it up here.
Qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right,
Okay.
that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report.
Notice Hank Brennan said Mr. Wing. Notice Alessi is saying, Lieutenant Wing. Oh, so he's like a police officer, which means he's got some training. Remember, I thought, if it's Hank Brennan, he's like, all these cops are credible. I love them all. Just not the cops who are going to offer opinions different than the ones I want to hear. Isn't that interesting how that works?
The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites two specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby.
Chad, it gets a little sticky here for a second. Just hang tight.
My request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
So that's another motion. That's good. That's what we're going to hear next.
Understood. And I was just going to say, I am not going to get into the basis for that. I just wanted to, because.
Just go ahead. Just move on.
Yeah. So my request would be that a determination on whether or not there's a voir dire of Lieutenant Wing abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on at a minimum, wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right. So there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring.
Okay, here's the thing, though. When you do a mold of teeth, you don't use that mold then to say this is the bite thing. Like, the bite mark science has been thoroughly debunked in trials. It's garbage science nowadays. Bite marking out, like using dental records to identify bodies, sure. Or using teeth, a mold impression to do orthodontics and things like that, or oral surgery preparation, sure. But this idea you're going to take like Chloe's mouth and then find a cadaver and go like chomp, chomp, chomp. Oh, these are her marks. No, you don't. We don't do that with people anymore because it's garbage science. I mean, like none of these people are veterinarians or veterinarian orthodontics. I mean, there's probably some veterinarians who focus on orthodontics. maxillary and mandible and maxillary surgery and dental things. Although mainly when you're a veterinarian, you do dental stuff for animals too. But like none of that's coming in. So the idea you can dog biting analysis. No. So this idea he's going to say we can include or exclude the dog. No, I think you could say this is consistent with the dog or it's not consistent with the dog. Here's the problem though. If you say it's a dog, but it's not Chloe, then where's the other dog that bit the shit out of John O'Keefe? Because this idea that there's some, wild pack of roving hounds going through suburban Boston in the middle of a blizzard doesn't make much sense. Gnawing on John as he's freezing to death. So I don't understand why Hank Brennan thinks this is a good idea. Like these wounds are not indicative of getting hit by a car. They're not indicative of getting drugged down the road. They look like scratches or something. They just don't look like normal car accident wounds. And I think that the state trying to get involved in that, they should be better off saying, look, don't worry about that. Focus on the I hit. If they want to win something, they focus on the I hit him. Focus on the black box technology they've got a hold of. Focus on Karen's statements. Focus on what she said to Jen McCabe. Focus on all that stuff. Focus on the fact she was drunk as a skunk. There's all kinds of stuff they can focus on. But fighting over this dog bite thing, this is where I will give Yannetti and Jackson credit. They've even sucked Hank Brennan into this fight. And Hank Brennan is now having to disprove this thing of like, oh my God, I have to disprove the dog thing. And it's like, you don't. But he's got he's diverted his attention onto this, which I'm surprised Hank Brennan got sucked into this. So where's their black box? Well, the vehicle control unit. There's the black box in the car. So, yeah, it's a thing. It's a thing. So, that apparently did get downloaded and has actually been analyzed now. Who knows? Because we haven't heard anything about that data. So, let's see here. Brad is saying Chloe chewed on a pig's ear toy. Maybe. Who knows? We don't know because it hasn't been accounted for. Yeah, all it has to prove is that John was attacked because it introduces doubt. Yeah, but they're better off just saying, like, you don't know what the hell those came from. And they just focus on the fact of Karen hit him. I think, like, him going down this road, I think is bad. Sweet tooth, there you go. Oral maxillofacial surgery. But I don't know if that's what you call it when you're doing things on animals. So where's Clyde? Clyde is hanging out with 2.0. Yeah, Brennan was practicing when bite mark analysis was discredited. Well, I know. Well, it's been the last 15 years it's been discredited heavily. It's a disingenuous argument. I know. So, I'm very surprised. I'm just very surprised you can do this here. Like, I just, trying to, I don't think you're really going to be able to include or exclude the dogs because now you're getting into, you could include or exclude people. You could say, is this a dog? Yes. But is it this dog? I mean, like, absent clear missing teeth or something like that, I don't think you really would be able to. So, I mean, you might be able to say, like, Clyde versus Chloe. Yes, Clyde's got a little, like, cheap bite versus a raw bite from the Chloe. Yes, you could tell those, but that's about it. So, here we go. We're going to keep going.
The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable or consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds show to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you.
Yeah, I don't think this is going to go the way he's planning. We'll see. We'll see.
The substitute chemist. Is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim 63.
Sounds like a chemist they were using for something no longer works or is available, so they're having to bring in someone else to read lab results. And you know what? It sounds like the state doesn't care, or the defense doesn't care. Doesn't hurt the case. They're like, whatever. It's all good.
3 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's going on?
We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay. Thank you. Can I have the defense what you intend to put up?
It's a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
Yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay,
Can I make a note?
yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay.
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent.
Well, yeah, it sounds a lot better than, you can't have anybody like reading emotion into it. But why don't we have the shitbag detectives read it? It's not like bring in Trooper Proctor. He's got free time. He's not working anymore. Give Trooper Proctor, pay him a couple of bucks. Pay him a per diem. Hey, Trooper Proctor, here's like $50 a day. Come in and read this. In between having to testify about being a piece of shit. Just have him come in and read it. Like, they could do that. It'd be great. He needs a job. We're like, this is the new economy, chat. We're uplifting people. He needs a job. We got a job. And then who else got fired? Who else got fired? Who else got fired? Did Tully get fired, or Guarino or Guarini? Or was it just Trooper Proctor that got fired? I forget. Who knows? But yeah, just Trooper Proctor. Okay, but yeah, bring in them all and bring in the bums. Let all those dishonest bums come in and read. That'd be great.
Reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right, how are you going to find this person?
But we could have somebody plain clothes from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that.
Plain clothes. You notice he said there, I don't want people wearing state police uniforms. Huh. Why can't people wear state police uniforms? Because the jury is going to find out the state police in this case are a bunch of rats and scumbags who can't be trusted. So guess what? Anybody wearing a state police uniform is going to look like a rat and scumbag. So if I were them, I'd say no. If they're cops, they need to show up in cop uniforms. Normally, you wouldn't want them wearing a cop uniform. But here they need to be, because now they're wearing gang colors. And this gang is full of bad people. I would have them ham it up. I would have them do it. She's prohibited witnesses from wearing cop uniforms. I know, but I'd say no, Judge. Let them wear their work uniforms. Let them wear their work uniforms. It'd be great. Yeah, half the cops aren't cops anymore. I know, that's the beauty of it too. So that would be the best thing.
That role.
Okay,
May I have one, Your Honor?
yes.
Oh, they're working on something. Here we go, chat. Hold on.
I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Guarino, I can't remember his first name, Mr. Guarino, to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a
And that makes sense. Just have the guy who found him bring him in. Like, why can't we just do that? Why do we have to be special, Hank? Why does this have to be special? Well, I mean, we know why, because he wants to use this to screw over Karen. So,
Witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who was not a witness to those text messages to come in and read them continuously through the trial. Mr. Guarino is an independent witness in this case. To bring him back regularly as a police officer, I think is creates the wrong impression. I think objectively, we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Guarino is the one who found, if he's a state trooper, he found.
Kathy, you asked a question. Remember, Kathy, guys remember Kathy, you're a realtor in New Jersey. If you need to sell property in New Jersey, find Kathy. We need to buy property in New Jersey. Find Kathy. She's your realtor of choice there. Why didn't they ask for a change of venue? I think they're actually happy using this community. I think they want this community because already, it's very politically charged, and I think they're trying to take advantage of it. I think initially they thought about moving it, but they decided to keep it here. So.
The text messages, he was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to
I agree, Luke.
Think
it's
that
a confrontation issue.
is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be. And the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Thank you. All right. Defendant's motion for specific discovery, paper 638, Jimmy. All right. Who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay. There's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay. Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay. I'll hear from the Commonwealth.
Number 5. Yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you.
I very
All
much
right.
I very much disagree. I very much disagree, but I think she's going to side with Hank on that. We'll find out in a day or two.
The ARCA witnesses. Motions
we-
regarding that. So
And now we move on to the big one, Chad. Here we go.
where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps.
Now, guys, you might say, wow, this is really overbroad and Hank's really pushing his luck. Remember, though, the defense got caught basically lying about how they paid, ended up paying for ARCA. Remember, they ended up paying for him later, and then they never disclosed that fact. So had they not done that, this would have, Hank's got a lot of wind in his back right now on this topic because they got caught being dishonest. So had they not done that, they've given him the chance to do this in the grandstand. This is the problem here.
We could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination.
No, I understand Brennan got caught. But remember, Cannoni got all fired up about it. But remember, Alan Jackson, they never, disclosed they paid for it. Like, that's still being sketch. This gives him gas in the tank. And I understand the state. The problem is Cannoni isn't calling them out that way. Remember, she's only focusing on Alan Jackson and Yannetti. And this doesn't help. So you can't give him ammunition. Is the point.
And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an
Also, you shouldn't lie to court, but I'm just saying.
Order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welchure's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify.
You know what wasn't done discovery deadline wise? The Sallyport video.
They would be required to testify pursuant to their February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Okay, who's arguing this?
I want to go in reverse order briefly.
And this is one that Alan Jackson needs to argue because this is going to be good. I assume. Hope it's good.
If I could, concerning the discovery deadlines, we have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up.
There we go. There we go.
They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
What do you think a timely manner is? What ballpark are you talking?
When I get a report.
Well, I mean, like, that's a problem. Timely manner. We're like 3 business days from trial. Like, that's the thing. You got Thursday, Friday, and Monday. So how many more reports? Like, what do we got left? There ain't no time, man.
Report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. That's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but.
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13, another party says we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes.
It's a very good point of like, be specific. What do you want from us?
Response is that it's not in their custody or control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, well, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is
your tolerance. He's like, my clams are so steamed. I'm up to here, by golly. It's like, chill out.
extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
The
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So address number one, please.
I
Okay.
am. That's what I'm doing, Your Honor. We have provided on April 12th, about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Welchure. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with.
I had a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Welchure talked about what he did, which was more on the on the biological side.
There's a difference
Right,
between the
and
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it, and it's exactly what they testified to both in.
To be fair, that is an issue about specifically what did each person do. That's not. There's nothing wrong with just making sure that's fully delineated more.
The voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
Right. Ms. Little I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes, that is on.
Now, it'll be interesting. ARCA can't talk about what they talked about with the DOJ. But if you pay attention to their testing and what they have tested, you could probably figure out what ARCA was asked to do and what that means the DOJ was curious about. So that's the thing, though. You could infer what the DOJ wanted based on what was tested.
Can they testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely. That is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential.
And can I see Counsel Taggar, please?
All right, chat. We're going to skip ahead here. I don't know how long they're in sidebar. Jeez, they're in sidebar for a while. God, it's like a 10-minute sidebar. Phew.
All right, so Mr. Jackson, you're saying that the ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and that was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into effect.
When did it start?
I don't remember the dates. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There are 14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then
from
you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welchure, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welchure was provided.
All right, so when did
that's
you
what
do?
we provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26th, 2025. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welchure had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh,
You
I
said-
didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing
You must not have done a very good job because it still happened.
would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a TUA request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes.
The biggest thing here, though, is these ARCA guys are having to respond to your witness now. You have your own expert that came in. They have to respond to that. So, I mean, you know, he's like, I can prepare for some of it, but not all of it. And it's like, you sound very scared of ARCA. He sounds very scared of ARCA. But he's also brought in his own witness, which they now have to analyze and take a look at themselves. Chugi, now you don't understand what the issue is. So his issue is he thinks he's going to try to cross-examine them on stuff, and the ARCA guys are going to be like, well, you know, he's going to ask him a question about some of the stuff that he wants to get into. They're going to go, sorry, that's at my office. I don't have it with me. Or what'll happen is, with an expert, I think he's also worried, like, they'll show up that day and be like, oh, hey, you know, Alan Jackson, here's another report or some other information. And now Alan Jackson has to give that to Brennan, like, the day of testimony. And he doesn't want that either. So those things he's correct about. You know, you do have the right to say, like, no, I need everything, like, ASAP. This does become an issue, though, because you're dealing with the federal government. And because the federal government, you're trying to get information and documentation from ARCA, who is a contract, like they are a federal government witness. You have to go through a TUI request, and it's a federal case where that's how you have to do this. When I was an assistant prosecutor, there was a task force in the area, and the FBI had an FBI agent who came out all the time and helped out with things. Well, there were a couple times where he would be involved in like a raid or on an arrest with somebody and searching them or helping search the car for a guy. And he, we had to determine whether or not he was critical to the case, because if he was, we had to send a TUI letter to the U.S. Attorney's Office in Cleveland saying we would like this FBI agent to come testify. If we didn't need him, we didn't ask for him because it was a pain in the ass. Because the federal government can always go, no. And guess what happens? You're screwed. So he's also bringing up the idea he doesn't need Alan Jackson trying to sandbag with more information. So he's demanding they bring everything with them. Now, I can't imagine how much crap that is, but this is what Brennan is crying about. I don't think he needs all of this, but whatever. Let him cook. Let him cook. And that's the thing. Alan Jackson questioned him blind without any prep the first trial. I agree, Aaron, but since then, they've had time to get more information and prepare more. So I don't blame Brennan for saying, I want more stuff, but the way he's throwing a tantrum here, yeah. And yeah, that's the thing, ultimately. Brennan's expert's going to suck, and he's going to have to cry about it. Ag saying he could have always retained ARCA as well. I don't think they can afford it, and number one. But number two, that doesn't mean ARCA's data becomes his data. It's the federal government's data. It's their property. They're the client. So he doesn't just get access to everything. And remember, he doesn't know what the federal government asked ARCA to do. So retaining them as an expert saying, can you do the stuff you did for the feds? That doesn't work because they can't tell you what the feds did. So retaining them doesn't actually do a lot there in his situation. I get it. It's a good idea, but it doesn't help him. So he's got a couple of valid points, but a lot of this is just stomping his foot and getting mad.
Takes away the Commonwealth's ability and right to prepare. It creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionists they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judge Welchur's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a TUI request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is
here's the problem, though. If your experts can't watch what the ARCA guys did before and figure out enough of stuff, these experts sound like they suck. A basic idea of what's going on. This is an issue. This is an issue. I don't know. I don't know how they can't see what Welchure and Wolf testify to and not have a way to explain things. And also go off of the report and information we had the first time around. Because remember, they had reports and information, and all that stuff happened really late because they were still federal witnesses. But like, you have all of that. If you can't figure it out, dude, it sounds like your experts suck. At least a basic idea.
Continued pattern from the last trial. They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judge Welchure's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked.
And now he's bringing up, look, your expert took so long, it now backs us up. Once again, the defense is pointing out, this is your fault. This is the state's fault. This is the Commonwealth's fault. We're reacting to the world they set up.
For a 2-week request. We asked for a 2-week permission, or asked permission to engage them through a 2-week request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day, provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judge Welchure's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judge Welchure's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody has had a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judge Welchure's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November. And then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadline.
But you really didn't. Notice he's like, this is the funny part. He's like, they won't accept blame, but I'm not guilty. They're guilty. I mean, this is what happens. They're both pointing at each other. It's like, no, you. You know, they're both throwing down reversal cards. Yeah, they're both going at it. You know, in reality, they're both screwing up. They both haven't done this right. And I get it. They both haven't done things properly. But they both can't concede anymore.
Deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right. Thank you. I think is the only thing left the motion to sequester Aiden Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes. Where do we stand with that? I thought that you were going to.
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right. So I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit.
That's kind of weird. How did this one not? Huh. It's kind of weird how that didn't come in that way, or she didn't get the motion. That is a little weird because she's like, "Oh, I see it there," but whatever.
The sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of.
Excuse me?
We need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right. Get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay.
So if it's already been briefed, that like it said, this is weird. So she's like, I filed a motion. I don't have it. But she's like, I know which, it's like motion 589. And it should be like this guy here, like the court staff here, like maybe not her, but definitely this guy who's like the bailiff. He should be like Johnny on the spot with that. But it sounds like the state's already responded too. So it's like, we're good. Your court clerk sucks too. They all suck. They all suck. Guys are.
You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
So chat, yeah, I mean, it works out. They get a chance. Oh, hold on one second. Just checking on 2.0 chat. We love our 2.0, don't we? So let's see here. No, it's interesting. Like, we look at how we did this, chat. We are through.
I would say that's only the audio. There's a visual.
So, oh, hold on. Here we go. So, what do I think we're looking at with this? Well, how do you feel about Judge Cannoni consuming more White Claws than me? I don't know. And then why do I need so many more books than Bev does, Sean? I don't have that many more. I just have a couple up there. But I mean, in reality, like, judges don't use these anymore, but they kind of have them on hand. Now they look. You got a bookcase. You got to put legal books in it. But she's never going to open these books. These books probably aren't even up to date. You just use your computer. But what's happening here? Well, the issues of internal disciplinary actions. If there's ongoing stuff, you're not allowed access to ongoing investigations. But if there's findings, notice, they want the findings. They want to discuss those. Not necessarily the investigation results, but what were the findings, what was sustained against these cops. That's fair game. That's fair game. And I think that alone is going to be devastating. But yeah, I mean, I guess why not go for broke and try to get it all? Maybe they know Cannoni's going to be like, no, you're not getting everything you want. But we'll see. We'll see. Anyways, here we go.
Court is back in session. You may be seated.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay. All right. Were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Bupnik, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
Okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay. Can we address it? Is it something you need for your opening?
It's not.
Okay. All right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay. So now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay. So, Jim, you have that. All right. I probably have it here too. I have one, Jim, thanks. All right, I will hear you. Let me just ask, Commonwealth, you're moving to,
Now we're into the
you stay right there, Mr. Brady.
Well, now we're in Turtleboy mode, chat. We're to the Turtleboy stuff, and this is Turtleboy's attorney. Lotus Mouse's working in a courtroom seems stressful. Like, when this stuff is going on, yes, but overall, it's pretty chill. As long as, like, the attorneys are cool and they get their jobs done, it's pretty laid back for the court staff. But if you have attorneys that suck, I'm sure it can be stressful. So... Edward Scott saying, and Eddie and Jackson both have a ton of cases. The only more frustrating than the lengths are going to frame an innocent woman is how badly the defense half-asses everything. I don't think they're half-assing it. I think there's so much more that could be done, and they could do things by the numbers. But they're cutting corners here. So, wait, what did I do here? What did I do? What? Hold on. What did you say in here? Why did I get 2.06? Thanks, sweetheart. I had a sinus infection. I can't give that to you. You know, you guys are sitting there taking the word of a fed, and you're just, she says, and you guys are just like sitting there like a dog, just like, just lapping it up. Just lapping it up from a fed. That's what you're doing, chat. You're really going to sit there and let the feds manipulate you like that? You really going to do that? Her Zionist handlers, you know, and her overseers. You really gonna fall for that? Think about it. Think about it. Think about it. What's that? Granola says, who is 2.0? Oh, well, 2.0 is the future Mrs. Martin 2.0. She is my betrothed. We are engaged and we're getting married next June. But she is the future Mrs. Martin 2.0, which implies there was a Mrs. Martin 1.0. And there was. And she's no longer Mrs. Martin 1.0. So when we get married, she'll be Mrs. Martin 2.0. And you get to see her in chat breaking my balls. And every once in a while, you can hear her breaking my balls. So, yes, she provides things. Yes, June 2026. Yes. So here we go.
You know, Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is a strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradel.
All right. Thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is
And that is because, remember, guys, Turtleboy is facing indictments for witness intimidation, like 19 counts of it right now. Also, remember, though, under Ohio v. Reiner, he has the right to remain silent, even if he's innocent. If he thinks there's a reasonable basis, he believes he could be charged with a crime. So Ohio v. Reiner is also in play here.
the government's, the obviously well-established position of Norfolk County law enforcement, what we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness
Okay,
intimidation.
so just focus back on,
So the answer is yes. I'm sorry. The answer is yes, Judge.
okay? So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was I'll hear you, Mr. Brennan. And you
Oh, I'm sorry.
But that's okay. I don't want to hear about
Got
the
it.
witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But
And
as a predicate, he would need to assert his Fifth.
do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
And I don't blame Brennan for saying that. No, I'm going to force him to come up here and assert his Fifth Amendment right. Nothing wrong with that. And I did, and I will admit, chat, this part I did catch. I was listening to Emily Baker this morning because I was driving around when this happened. In Massachusetts, you don't invoke your fifth in front of the jury. You invoke it outside the presence of a jury. So they're going to do it here in the courtroom.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
We'd reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
7 minutes. 5 minutes.
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
So she's going to talk to Turtleboy. They're going to be on the record. This transcript's going to get sealed. But it's her discussing with him, you have the right under the Fifth Amendment to not testify. Unlike Karen Reed, people can infer things from Turtleboy's assertion of his Fifth Amendment right. Now, how does that work? Like if this was in Ohio, well, we wouldn't have, if depending on what the situation is, if it's a defense witness, if it's a witness that's going to hurt my client, I would ask they assert the Fifth Amendment outside the presence of the jury. But I might not be able to get away with that, depending on what the judge wants to do. If it's a prosecution witness or a witness that's helpful to my client, and somebody I'm going to bring in or the prosecutor is going to bring in, I would demand, no, Your Honor, it has to be in front of the jury. We have the right to confront this witness. So it'd be I can understand why wanting to fight it, but let's see here. We got to get to the end of this. So we're going to skip ahead. And we are there.
All right. Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right. So you're not asking for a Lewin Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right. Thank you.
I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Carney that he would in fact invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Karen to restore his fit.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradle. And all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
They're making sure that this is the sealed recordings from here. So the Goosey, how you doing? Hope you're doing well. Remember, guys, kind of like the document queen out there, getting everything put together, following along on all the big cases. But yeah, they're going to have Turtleboy come up and talk to Judge Bev. And she's going to say, like, do you understand what you're doing here? And it sounds like he's live right now and kind of doing the opposite of it. So, it is what it is, Chad. It is what it is. So it looks like here we go.
All right. So, Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege. And I find that if he were called to testify, he would, in fact, invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the 2 minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them.
All right, chat. So real quick, what happened there? So you heard the judge ask, Hank Brennan said, do you want a Lumen Martin hearing? So if he's going to assert his Fifth Amendment right, Hank Brennan has the right to figure out, what are you going to assert it for? And what questions can I ask that don't trigger that? What can I do to, it's this, and this is where I'm kind of addressing this, Erica. This is where you could kind of like, you're going to throw up the Fifth Amendment walls. Okay, but where does that wall end? And I could get around it. What questions can I ask? How can I like bob and weave to get to those questions I want to ask you? The problem for Hank Brennan is a lot of those questions and poking and prodding around at a hearing, which would be on the record, would require Turtleboy to probably invoke his Fifth Amendment right a ton. And there's also limitations on what they can talk about. Remember, there are basically like gag orders in place that they aren't allowed to disclose things. So as he said, there's stuff I'm not allowed to disclose. The judge has pretty much embargoed that case. So because of that, they're limited in what they can do. So Hank's saying, not only is Turtleboy going to, have a lot of what I'm going to ask is going to touch into these areas he's going to assert his Fifth Amendment right to. I'm limited in what I can talk about and that I know of in the Turtleboy case because that judge in that one said, you're not allowed to run around disclosing stuff. So Hank Brennan's like, my hands are tied. So yes, Hank Brennan's better off. He doesn't need Turtleboy to win this case. If it really did come down to Turtleboy being the linchpin to Kieran Reed's convictions, they're fucked to start with. So that's not going to happen. It's really, they have other stuff they can use to prove things here. So, Trump once says Turtleboy's Christian name. No, it's a government name. So, yeah, he only put Turtleboy on the witness list to keep him out of court. Yes. So what does that mean, though? Just like the last time in the first trial, when the Alberts and the McCabe's and all those people come in to testify, he has to leave the courtroom. And then as soon as they're done, he can come back in. So I still think that's nonsense. I still think that's a violation of the First Amendment. But, you know, it is what it is. That's why Bradel said, we still have our objection from last time, but we're not going to, our same argument stands. And she's like, your objection's noted for the record. So that's why there. But Sellers is saying, you want to understand how the steno mask works. And that's the lady down here. It looks like she's like, you know, too close for missiles. You know, Maverick, you've got bandits, 200, 110 miles. In closing. Yeah, I understand you want to do that. We'll talk about this here. But yes, this is ultimately that. Now they're on to the stipulations. Remember, stipulations are facts that have been agreed to that the jury no longer has to decide. They can accept these as proven.
All right, this looks like you all made some progress in a way where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy.
And it is something that we've done.
Right. Understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion.
Given to me. We're all set until Tuesday, I believe.
All right,
I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right, this looks like you all made some progress in a way where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy.
And it is something that we've done.
Right. Understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, so go please.
All right, chat. So there you go. Hey, we got pretty good, guys. We got through that pretty good. So I did pretty good. I got pretty close. You got all the way to the end. You got it. Suffer, chat. Suffer. Yes, the fan service. Yes, Ceiling Dion. Got a couple of comments we need to catch up on here. Siren the Cat for $2.79 Canadian says, Nick won't go to jail, but will he go to Stoney's? I don't know if he's going to go to Stoney's. Apparently he likes to go to the VFW bar in town. But yeah, I still don't think he goes to jail. Remember, guys, the probation department is just a recommendation. It's not binding. And, it's up to the judge. It's up to the judge. I still don't think he goes to jail. Have I gotten a paper cut in court before? Yes. I've gotten a paper cut before. I've got up and banged my knee before. I saw a prosecutor once get up and accidentally, funny bone their elbow on a podium before, and they, I've seen all that. I've seen all that. I've seen had happen. Not necessarily in a trial, but I've seen it during pre-trials or when there's a cattle call and it's just a room full of people. I've seen all kind of stuff happen. Simon's saying, does next retrial she get to be the judge? Yes. So she is the judge coming up for the next trial. She is the judge until she is removed. So let's say there's another hung jury and we get another mistrial. And then they want to try Karen Reed again for the third time. Judge Bev would be there for the fourth time, the fifth time. Until they were, like, if they got her recused, she retired, or, you know, like she died. Those are the only three ways Judge Bev is leaving the case. Even if you change the venue, you know, she's going to follow the case along. So, yeah, she's not done. She ain't done. Brandon says, hey, Judge, I have a novel bite mark and tool mark argument. I replaced most of the R's with H. Pretty cool, right? Discuss at the gay bar later. Thank you, Brandon. Kathy says, why did they ask for a change of venue? I think I mentioned this earlier. They think this community is supportive of Karen Reed. I mean, they already got a hung jury, so it's like, why not keep it here? They like the people. They're supportive of Karen Reed. And then Kathy, you're a realtor in Jersey. Remember, guys, if you got Jersey, you got stuff in Jersey, trying to escape or move to Jersey, get a hold of Kathy for $10. Thank you, Kathy. Is saying, Sean, let's reprieve our readings. Let's read the text. We might do that one night coming up here. That would be a lot of fun. That would be a lot of fun. Let's see I wonder if we can get some people in for that. That would be a fun time. Green Caps Lock, who's been a member for 13 months. Thank you for the support. Says, is Hank whining because he needs a diaper change? Yes. Probably. After the saying, is it just me or does this seem more personal for the attorneys in most cases? Yeah, it does. For Alan Jackson and Yannetti and all these guys, they have a massive rapport with Karen Reed. They believe in her case. They've, tied themselves to this. It's kind of like the Indian fighters who would tie a stake. They tie themselves to a stake and pound that stake into the ground. And they'd fight they'd fight the U.S. Army when they came by. I mean, they've dug in on this hill. They're fighting to the end. Like Taylor Swift said, it's either going to be forever or it's going to go down in flames. I mean, even Hank Brennan. Hank Brennan is, a pretty high profile attorney in that area. He got, the prosecution, the Commonwealth was like, hey, brother, can you help us out? So Hank Brennan's really invested in this. He got tapped to come in and be the ringer. Like, yes, there is a lot in this case. But here's the thing, guys. I mean, yes, on this, but let's say there's a drug case or something small, like a domestic violence case or things like that. The little things get heated too. I mean, you can get invested in a case very quickly. Very, very quickly. So it happens. It happens. Soothie Goosey, hello. And then Luke is saying, it looks like Hank has learned to make a narrow request. That'll probably get granted. Yeah, I mean, he's getting better. He's learning as it goes, but we'll see what ultimately that does for him. Did I just quote Taylor Swift? Yes. Yes. Blank Space is probably one of her best songs. Let me see here. What's the most time someone has been retried? I don't know specifically, but a lot of it's not uncommon. It's not uncommon. Let's see. Most times someone has been retried for a crime. There's a guy in Mississippi who got retried 6 times. It's a guy who's been found guilty 6 times, and every time it got overturned. But it can happen. It can happen. I mean, it's there are people who've had 3-4 trials, and as long as the prosecution is going to retry you, they can try. They can try. So it does happen, but not a lot. Generally, it's going to be like murders or something like that when you get a retrial. So, let's see here. Let's see. Marcus Roberson was tried 8 times. Yeah, it happens. Morrissey says they will never drop this. Yeah, I mean, they say that, but eventually people are going to be like, let it go. Let it go. Yes, it's a case out of Mississippi, that one I've looked at, I think is very interesting and would be worth looking into, I think. If you guys, I think, would enjoy the story behind it. I think you guys really would enjoy the story behind it. So, let me see here. I think that's kind of it, though. Kind of all caught up. So, yeah, guys, that was Karen Reed. Yeah. I still think there's a very good likelihood she gets convicted this time around, guys. I'm being serious, being honest with you. I mean, guys, you understand what I do here. I don't gas you up. I don't gas you up on anything. There's no point to that. I'm not going to lie to you. I'm going to tell you the truth. She's probably going to go to jail. I mean, she's probably going to get convicted. Sadly, she's going to get convicted. I don't know of what, but she's going to get convicted of something. Just the idea you can keep like hanging out there. Let me see here. Ooh, this is nice. Oh, yeah. Got a motion to dismiss with cost for the state. After further review, all evidence of the findings for the prior county prosecutor's office, the charges levied against my client should not have been processed. Wow. That's a good day today, chat. That's good news. Good news. And pure gas. Char. Does it help or hurt Karen if Bev turns up in the snow on the Albert's lawn? Oh. Bella's saying, well, when people learn to shut their mouths. Here's the thing. Karen Reed not talking is not going to sink her. Hank Brennan, being a defense attorney, he understands better. Lally was just a bad trial attorney. I think more properly equipped prosecutors may have been able to convict Karen Reed right off the bat. So, I earned that coin today, yeah. Did I hear Fannie paid Ashley Mercon $54,000? No, but that's good news. Sounds like an all-nighter is in store to celebrate. Yeah, it was all right. It's a simple domestic violence case. But my guy, he's like, he's like, I did what I had to do. He's like, I'm not ashamed of it. I'm not pleading out. It was self-defense. And yeah, we kind of, we dug in and dug our heels in. So Brewberry says, I didn't answer your question. What was your question? Oh, that, yeah. We're moving on there. You think, I think she gets manslaughter. I bet she gets manslaughter. I kind of bet that's going to happen, guys. You know what? Call it now. Karen Reed she'll probably get convicted of manslaughter. Hope she doesn't. But like I told you, giving you the real answer, not the nice answer. So, Luke says she burned this in her self-defense. It was not a man and woman situation. It was two brothers. Brother A started a fight with, they're both grown. They're both in their 30s. Brother A started a fight with their mother, and Brother B came in and just started beating that ass. And they played rock. They went at it. So it wasn't a husband, wife, boyfriend, girlfriend thing. It was two brothers fighting. Is it the lock of the week? Yes. Yes, it'll be the lock of the week. And we got 2 locks of the week, chat. You could take them to the bank. Nick Mercado will not go to jail. And Karen Reed probably will get convicted of manslaughter. So, Garrett's saying she did leave her shoes on when she went to John's house. Yeah, but I get and I understand why they brought that up. You're showing like she knew John was dead. Now, the bigger thing is you could show she's blitzed out of her mind and still completely drunk. I mean, like you could do that too. There's ways they could have used that. But they went way too hard into the murder thing. I think manslaughter is probably the better charge, or vehicular like manslaughter. But charging this as like a fucking murder, that makes it harder for them. And I don't know why they did that. If they had just had this manslaughter and then the, leaving the scene of an accident where an alcohol-related death occurs, she probably would have been convicted probably right then and there. But throwing the murder in just seems so stupid. Speaking of Ohio brothers committing crimes, am I covering George Wagner tomorrow? If I'm back in time, I will. If I'm back in time, I will. If you have a link, can you have a link? Because I'm going to be like actually working tomorrow. I've actually got a lot of shit to do. So, Jim says, what were all the rulings on this? Well, a bunch of them haven't come out. The judge is going to make a ruling on a bunch of stuff, but one of the bigger ones is Turtleboy is going to be allowed in the courtroom, except for all the witnesses that he's accused of intimidating. So, murder makes sense only if you try to use the interviews. I don't even think the interviews help. Murder is just hard because it's like, you're going to have to prove that's a murder. I don't see how you could prove it's a murder. It's manslaughter at the most because, yeah. So, but we'll find out a lot more of those tomorrow, Robert. If we find out more, we'll talk about them on the Thursday night show. God, my voice is getting all froggy again. Yes, Aaron. I mean, like, all that stuff is weird. Well, yeah, Brewberries, here's the thing. If she took her shoes off, they'd say, well, she was so worried about not finding John, she took her shoes on and off. That doesn't make any sense. Remember, everything you do can be used to make you look good or make you look bad. Everything can be good and bad. Everything can be good and bad. So. It's a conscious and guilt argument for murder. Yeah, but the Aruba stuff, like, I can understand they're using the Aruba stuff to say she's got that simmering hatred. But more importantly, I think the Aruba stuff is better to show manslaughter, that Karen Reed is so emotional, she like, and explodes. I think that's the bigger thing there, because I think part of their argument is that her and John had some sort of argument. He's like, fuck you, bitch. And Karen's like, I'll show you, you motherfucker. And just like, bam, runs into him and like hits him. I think that, I buy that. Like, I don't agree with it, but I think that's a far easier sell, that Karen's a fucking lunatic who, she gets sets off like that and emotionally overreacts and sell manslaughter. I don't see selling murder is so hard. Selling murder is so hard, in my opinion. I don't know why they're selling it. So, okay. So, all right, here we go. So stuff just came out today, guys. One of you guys has mentioned it, so we'll address it real quick. So it's about the ARCA witnesses. And let's see, I'll bring up the other page so I have it. Because who just brought this up here? I want to make sure I give you credit. Yeah, he said Aruba's not coming up this time. I mean, they say that. That doesn't mean they can't bring it up. Yes, Nick, ARCA is in. Thank you for bringing that up and notifying us. So here we go. Luke says, I think that's their murder argument. Yeah, but that's more manslaughter. I think that's more manslaughter. And I think if they go manslaughter, they get a conviction. Like, boom. They would have already had a conviction. They went too far into the weeds here. They went too far into the weeds. Ag, did you send me a link too? I don't have my Twitter open. Let me see. Okay, yes. Ag, hold on here. You're sharing me a post. Don't see it. Don't see it. So. Let's see here. Let me see. So here we go. Here we go, chat. We've got the Karen Reed updates. So here we go. So this is the court's ruling on the ARCA stuff. We knew this was going to be coming out because this one's kind of important for the time-wise on things. So the Commonwealth moves for an order to compel the defendant to produce discovery that they haven't produced previously. Also request court order the defendant to certify its discovery obligations are complete. And limit or preclude the defendant from requesting ARCA conduct any further review or testing. As there's no the written submissions, it's ordered that by April 18th at 5 p.m., so Friday at 5, they have to produce any outstanding discovery listed in parts 1, 2, or 3 of the Commonwealth's motion, which are, this is, all bills, invoices, contracts, retainers, engagement letters, or payments that have been created for the defense of Karen Reed or provided to or from the Reed defense team from March 1st, 2024 to present. So what does that mean? That means all the DOJ stuff is not coming in. And this is very specific. And 2, all emails or letters or written correspondence at any time between ARCA and any member of the Reed defense team, including Karen Reed, which that is very sus if she's involved in that. It's very stupid. All phone ledgers, evincing phone calls or text messages between ARCA and any member of the Reed defense team, including Karen Reed. They must have some reason to think Karen Reed was there too, or got involved in it. That's so freaking weird, man. This is so freaking weird. So freaking weird. Like, they must know something. They must know something we don't know or have a suspicion that we don't know. I don't get it, but hey, they do. I think you guys can read that from here. Yes, you can. So, hold on. What do you guys want me to? You guys want to poll? Copyright Kurt says, Runkle's doing this topic. We should all leave and go there. Yeah, thank you. I appreciate it. Runkle does great stuff. So if you went there, you wouldn't be disappointed. I promise. I promise. Do I think the other side's going to ask for the DUI lesser this round? I think Hank's going to, because Hank needs the win. It depends on how bad things go for the defense. If it goes well, they won't. But if it goes poorly, I think they will to protect themselves. I think they will to protect themselves. So, Captain COVID said she's not ruling on ARCA. Literally, she's ruling on the motion to compel regarding the ARCA witnesses that we talked about. We literally just had the hearing on. So yes, this is about the ARCA witnesses. They're coming in, but the issue is about the discovery, their information. So like, yes, literally the thing we just watched, she's already made a ruling on. Like, it actually has just literally happened. So, and they talk about, in addition, by April 18th at 5 p.m., the defendants must disclose the Commonwealth any oral representation agreements or understandings regarding the anticipated reimbursements or payments to or on behalf of ARCA between any member of ARCA and the defense team, including the defendant. Once again, if Karen Reed's talking to them, shame on Yannetti and Jackson. Something's weird there, and it doesn't make any sense. I don't get it. I don't get it. So with that said, by Monday afternoon at noon, the defendant must disclose to the Commonwealth any testing that's already underway, requested, or contemplated. And they say, as to anything that hasn't been actually set up and done, the date the testing will be completed, and then they need the results of all the testing. And this is where Bev says after they get this, the Commonwealth can come back for another motion if they need to. So there we go. Captain Cova said, okay, that was new to me. That's all right. It's all good. So. Oh, Captain Cova says, I didn't think she did from what I watched today. No, it's all good, man. No worries. No worries. Luke says, if the state goes harder to manslaughter and ditches the murder, I think they'll ask for it to give the jury an easy out. Yeah. Because even then, Karen's still facing some time. Seller says, isn't the DUI past statute of limitations by now? No, because she's been charged. She's already been charged, and if a lesser included offense exists, it's fair game. So statute of limitations are running, but once you get charged with a crime and you're in the middle of it, then it's not like it's a new offense that got in there. It's just the state has proven a lesser included offense. Or sometimes, as a defendant, you're aiming for a lesser included offense yourself. So yeah, once there's charges, the statute of limitations no longer runs because charges have been filed. Yes, J-Rock, you're saying it's already charged with the statute of limitations. Yeah. And there was actually a case where I remember I was in Toledo at the time, and there was a rape kit the prosecutor's office had. They didn't have answers yet, and they indicted a guy, and they didn't have it all back yet, and then they got it back, and it was like because they were running out of time. But there were some issues about whether they charged and how they got it done. So it is a big deal. Sometimes it can be a deal, but generally it's never a problem. Afton says, could they add plain DUI to our outstanding charges? I don't know. In Massachusetts, that counts all the way down as a lesser included, just OVI or DUI. Maybe. Let me see here. I am not cheating. I know stuff too, J-Rock. I'm not the smartest bear in the woods, okay? But this 105 IQ could figure things out, let me tell you what. I know enough to be dangerous. Sweet says, I don't think she did it. ARCA is such good evidence. I understand. I don't disagree with you that I think there's a very good likelihood she didn't do anything. But I think at the very least she should be acquitted. At the very least she's not guilty. Although I think there's very good evidence to show that she's completely innocent too. But it's not 100% like bulletproof. There's a bunch of sketchy shit with Karen that doesn't, there's enough there a jury can say, yeah, this doesn't add up. All right, sorry about that, chat. Jeez, coughing up the... Been drinking water, tons of water, and, taking Mucinex, and I'm just like, before when you're coughing up, it was a little phlegmy, but now I'm just coughing up, and it's like just chunks of garbage coming up. Kind of am I dying? No. I had a really bad sinus issue over the weekend, and I'm finally to the point where, I feel like I'm out of the woods. I'm finally rounded the corner. My voice still sounds like garbage. But I'm coughing crap up all the time. It's getting good. I did a quick bong rip. Yeah. No, I did not do a bong hit. Oh, there, you sent me something funny. Okay, this is funny. Okay, so yes, chat, here's your Aunt Bev action figures. If you are interested, you can get one. The word sputum sounds disgusting and inappropriate. Yes. And there's your Aunt Bev action figures. You have year-round sinus issues. Oof. Yeah, but I've had them, and it's more of the like temperature and the weather than my allergies yet, because we don't have things pollinating really. Like our tulips in the front yard are just coming up. So you're at the beginning of the end. Yes. The Tito's bottle isn't big enough. Yeah, I heard Bev likes to drink. So, but hey, it's not the first judge who likes to tie one on. So yeah, guys. With that said, I think Karen Reed's in a very interesting position. We'll see how this shakes out from here. Like I told you guys, though, I'm trying not to doom. Just telling you how it go. Oh, apparently she's yelling at somebody. Are you yelling at Clyde? She's yelling at Clyde, chat. So, let's see here. We're gonna make sure that's done. That's done. That's done. No, 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 no. That's done. All right. Both the cat and I are suffering from the pollens. Yes. Blue Virus is going through the same thing as you every spring and fall. Yes. Oh, it's bad pollen this week here. That sucks. That sucks. Yes, right now your tulips should be popping up. Yes, they are. Our tulips, I think 2.0's had a chance to see them. They look amazing. We got a bunch planted last year in the summer, and they are just beautiful. They are just absolutely beautiful. It sucks. We don't have like the vibrant purple ones, but we got a bunch of pink. There's some yellow ones. We got a couple different colors along the way. So, let's see here. If Karen wins, she walks. Higgins wins, she goes to jail. If Bev wins, we all die of alcohol poisoning. Yes, I'm Holland maxing. Yes. Oh, in Minnesota, we won't have tulips for another month at least. Oh no. It's not even tubing weather in Minnesota yet. You can't even ride your tube down the river with a bag of stuff in your hands. Don't you know? Yeah, no, that's gonna suck another month for your tulips don't show up till May. That's kind of trippy. Why? What is Clyde doing that he's such a bad dog? Oh, Clyde's out there barking at all the neighbors. He's doing the whole, hey, he's like, Clyde's out there screaming like, hey, are there dogs here? And somewhere in the neighborhood, there's going to be another dog be like, yo, I'm a dog. Clyde's like, me too. I'm a dog. Come here, Clyde. I think people want to see you. Oh, you're all chilly, buddy. Come here. Come here. Hi, where are you going? Where are you going, Bubba? Oh my God, you are cold. You are cold, Bubba. So, yes, the Twilight bark from 101 Dalmatians. Yes. He's knocking my headphones off there, dude. Our neighbors are very nice, though. Oh, let's see here. Yes, the Twilight bark, yes. Stephen Bunt says, I'm late, but does this mean they'll do a beard rating stream? I don't have locals, but that seems kind of like that kind of content. I don't want to look bad with my beard. Oh, you want me to do like a beard, like a tier list? That seems kind of gay. I'm just saying Alan Jackson's beard just looks weird, where you just have a beard that goes like to here, and then there's no sideburns, nothing that connects. That's just weird. Like it makes the Amish beards look weird, like normal. And the Amish have weird beards. Does he have the Shih Tzu scream? What the hell is that? Hold on. Like, what is a Shih Tzu scream? A Shih Tzu screaming. Let me see here. What is this? Oh, hold on. We're going to try this, chat. What's a Shih Tzu scream? All right. Share screen. The amazing screaming Shih Tzu. Here we go.
This is Maniac Rose, and I'm about to show you the amazing screaming Shih Tzu. Watch carefully as I can provoke this dog to flip out. Wookie!
Okay, yeah, that's kind of how Clyde barks. He also barks kind of like a beagle when he's out barking. It's a little more like he kind of barks like a beagle, but it's kind of like that. So yes, he does have a Shih Tzu scream. What? Like a Shih Tzu scream? No, I mean, yeah, his bark is a lot more like a beagle's because he's got like a howl, but it's kind of like I can kind of see it. So, what do you think, Bubba? Huh? What do you think, huh? All right. Well, yeah, I can kind of see it. I can kind of see it. Yes, Clyde. Anna Wall says, "Who's the baby?" This is Clyde. Clyde T Dog, or if you're on Twitter, Chef Clyde 69. He has his own Twitter account, not run by me, someone else. There is literally a Clyde Twitter account, but he is our doggo. We got him from the APL coming up on 2 years now. Wait, it's been 2. It's not 3, right? Just 2 still, right? 2 years for Clyde, right? Okay, that's what I thought. For some reason I thought 3. But no, we got him 2 years ago in April. We just passed his gotcha day. April 10th was his gotcha day. We picked him up from the APL. And yeah, he's such a good boy. He's such a good... He smells something out there, but anyways, he's such a good boy. When he doesn't want to be an asshole, look at the camera. So, all right, Clyde, I'm going to set you on the ground, buddy. Here you go. He's such a good boy, though. Duchess of Descent says he's sweet. Yes, he is. He's the bestest boy. Clyde, the Haitians are coming. Yes. You ever heard a bunny scream? Yes. Yes, I've heard a bunny scream before. It's funny. I was actually out hunting rabbits with somebody before, and he shot, and he didn't kill it right away. So the rabbit's screaming, and the guy panicked because he's like, "Oh my God, did I just shoot somebody?" Because a rabbit screaming sounds like a person screaming, at least if you're not ready for it. And he was terrified for a second. He's like, "Oh my God, did I hit anybody?" I'm like, No, it's the rabbit. And he walked up to it and finished it off. But yeah, rabbits can scream. His beard was horrible. Yeah. Jordan says, "Okay, but she was provoking the poor thing." Well, that too. Clyde ignores the Shih Tzu screams through your headphones. He couldn't hear it. But I don't know. Sometimes he reacts to the weirdest things. Your doodle sings, yeah. Bobo does that too. It sounds like he's talking. HM says my dog started barking like crazy. Boo says, well, that upset my dog. I'm sorry. Steven says, oh no level of gay, only minor levels of gay is okay. So medium, close length, jawline, cut beard is okay. So long as I still have the sideburns. I'm going to say yes. The problem is, though, we all have different definitions of what does that actually look like. I mean, because that's the problem. Like, you can have what, like I have, but how are you set up? I mean, I feel like when it comes to beards, people have different interpretations of what they have. I mean, when I do this, like, I take a razor and I just clean that line. I know some people actually sculpt and cut it and do a little more. Like, I'm just saying it's hard because I don't exactly know what you think that means. I have an idea, but that doesn't mean that we're thinking the same thing. Anna Wall says, follow Chef Clyde. Well, there you go. He needs to celebrate his gotcha day. Yeah. Yeah, it's been 2 minimum. It has. It's just trying, like I said, trying to figure out. And if you guys want to know, if you go to potentiallycriminal.locals.com, we actually have pictures from the day we got him. And then over the course of that first like couple of weeks when we got him in April into May, and he was in really rough shape. Like you guys look at him now, he looks like a completely different dog. He was super skinny. You could see his spine. There were a couple times we found him. He was just sitting in the yard, just kind of sitting there, just staring off in the distance. Like we kind of thought he was gonna die. We thought like he found a place where he could finally relax. And sometimes for dogs, that's what happens. You get them, you take them home, and they're finally like, I can relax, and they just give up. And they go away peacefully. Like we thought that might happen with Clyde because he was in really, really rough shape. Got kennel cough. Like that was apparently starting when we got him, and we didn't see it right away. But thankfully, once we saw it, as soon as we got him home, he started getting it. We got him treated and everything. But Clyde was far from a sure thing for a while. He was far from a sure thing. Yes, just remember, Clyde coin will always remain strong in times of crisis. It is. So, yes, they played Bunny Screaming to mess with the Branch Davidians at Waco. Yes. Your dad got a turkey in Kansas today. Congrats. That's good. All hail Clyde. Yes. Have I heard spiders scream? No. No, I don't care about spiders if they scream. Their screams mean nothing to me. Spiders can all scream for all I care. Mutton chops or go home. I don't know if I could do mutton chops. That would suck. No neck beards. I mean, technically, like, I don't know because I'm fat, but like, I mean, kind of my beard's on my neck. A little bit. Yes, he looks like a plump turkey now, yes. And actually, hold on, you know what? I'll bring one of these up real quick. If you guys are curious to see how far Clyde has come. Let me see here. Let me bring him up. Let me see here. Let me see here. So this is Clyde on his first days. Let me see if I can grab it. Here we go. And here, hold on, we gotta fix something real quick. There we go. So if you guys have never seen it, this is Clyde when we first got him. He was a little guy. You could see his spine right there. He was a little guy. And then you could see, here was Clyde. This is like right at the beginning. Completely different dog. Completely different dog. So, yeah. So are we giving Wiggles content for free? Well, a little bit. That's free stuff anyway if you show up. It isn't a neck beard, that's an under chin beard. Well, yeah, but so it's heartbreaking, yeah, but on the positive side, we've got him. Doesn't have to worry about it anymore. So yeah. He's in a better spot now. Yeah. He's a lot healthier now, guys. He's happy, he's safe. I mean, that's the thing. Dogs are tough. Dogs are resilient. Sure, he remembers that, but for him, that's ages ago now. That's like 15 years ago for him. So, just making sure he's got all the days in the sun we can give him. So, guys, with that said, it's 11:30. We've got to get ready for tomorrow. We got the 9:30 show. We may have some other stuff. It depends on how my schedule looks. Like I said, I've actually got a busy day tomorrow. And I got them from the APL, not the ADL, the Animal Protective League. So, yes. No, not all dogs go to Vermont, Aaron. I understood that joke. So, Justin says tomorrow's like 30 minutes. Well, yeah. Yeah, it is heartbreaking people mistreat animals, but you know what? Nothing you could do about that except, take care of the ones who do get mistreated. So, with that said, chat, good night to everybody out there. Thank you for everybody out there on Rumble. Not on Rumble, but Twitter tonight. All 274 ghosts that are out there. Thank you guys for being here. Thank you guys for being here on YouTube. And until next time, chat, just because you did it does not mean you're guilty. Unless you're an idiot like Karen Reed and you keep talking to the damn press. And you might end up being guilty. And that's why you don't do it. So, have a nice night, chat. Take care, and I will see you tomorrow. Good night, guys.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fact?